There's going to be no winners, only losers. At a fair hearing meeting, there will be lawyers. You will be in a courtroom. You will be sworn in. You'll get up there into that little testimony box, and everybody's going to be looking at you, and you're going to be sweating, and oh my God. Okay, the judge, a good judge, and by and large, the times that I have presented at a fair hearing, the judges have been very supportive. They know you're nervous. They know you're not a lawyer. You're not a professional person to give testimony. I found them to be very reasonable and supporting and caring. It's very costly. It will cost the district, like I said, about $20,000 to enter that classroom. Now, if the district loses, or any part that the district loses, they will have to cover the parent's cost for that part. So if the parent is bringing up 10 issues and they only win 3 issues, then the district must pay 3/10 of all fees that their lawyer puts forth, including anything they want to ask for the advocate. Update your curriculum vitae before you go to that meeting. A curriculum vitae is your resume on steroids. This is your resume, but it lists every professional development class you've ever went to, every online symposium you've ever attended, every book you've ever read on the topic. It's 5-6 pages long. It makes you look like a hero. The opposing side, the parent side, they'll bring in experts, and the judge is going to take their curriculum vitae in one hand and yours in the other, and whoever weighs the most, well, that's the expert he's going to listen to, or she. I'm kidding, it doesn't really work that way, but definitely update your curriculum vitae. Answer only the question. Your attorney will prep you for this, your district attorney. You'll spend 6-8 hours with the attorney learning how to testify. And you know you've probably heard it, the attorney asks you, what time is it? And you say, oh, it's 11:55. You didn't answer the question. No, wait. How's it go? I got that wrong. The attorney will ask you, do you know what time it is? And you'll say it's 11:55. And the attorney will be disappointed, because the correct answer to do you know what time it is yes. And that's all. So that's the way they're going to want you to answer the question. You're going to want to support your side of the argument. So you're going to want to provide additional data when you answer those questions and demonstrate your knowledge and demonstrate your expertise. Don't. Because the attorneys have a long-term plan, and they're going to circle back around and get the information they need from you in the order they need it, so it makes sense. Know your report. Reread that report the morning of the meeting. Highlight. Do whatever you got to do. But make sure you know what's in that report. Make sure you understand the student's last IEP and can support it or not. If you didn't support that intervention, be able to talk about that. You're not going to throw the district under the bus. You didn't make the offer of FAPE. The principal did, and they probably did with a good heart and using all the knowledge and information they had. But the attorney will also prepare you for that. If there's going to be some areas where it looks like you and the district are going to disagree, the attorney will tell you how to handle that. And you be upfront with your attorney and say, listen, I was at that IEP meeting and I do not agree with these accommodations. And I made it clear at the meeting, but I was overruled. The attorney needs to know that. Preparing for fair hearings, mediations, even alternative dispute resolutions should take you hours. This is not something you do just a few minutes before the meeting. Don't do that. You'll go in so ill-prepared. You'll be nervous and you won't do well. Relax at a fair hearing meeting and answer the questions that's asked. So, how to help you relax? I want to end with this. The outcome of any of these is usually additional services for the child. That's usually the number one thing that comes out of it. It might, how does it affect you? It might mean that you've got to start counseling this kid once a week or something. Typically, it means that the SEI teacher is providing more targeted and more services. You're always going to learn something new from every one of these. So be prepared for that, and don't miss this opportunity to learn something new. You're going to learn what not to do. You're going to learn what to do next time. You're just going to learn something new. Sometimes the officer will require further training, that the district conduct further training, and that means that you got to attend some classes, go to a conference, document some reading that you've done, however the district decides to implement the training. Very, very rarely will a psychologist be reprimanded because of the outcome of one of these meetings. And when they are, they deserved it. They knew this was a difficult case. They knew they had not assessed the child. They had not administered the CAS, but they reported scores anyway. They lied in their psychoeducational report. That psychologist deserves a reprimand. But that's what you've got to do for that to be the consequence. Because everybody's going to, the judge, the mediator, the CELPA personnel are going to assume that everybody's coming into this in good faith and that nobody had the intention of harming the child. But there's a misunderstanding. So as long as you are not intentionally betraying the child, you have nothing to worry about as far as a reprimand. All right, let me stop the recording.